Hi, everybody. This is Steve Maggi from SMA Law Firm. Welcome to our top 10. Today's top 10 is the PERM or labor certification process. So what are the 10 most important takeaways that you need to keep in mind when it comes to PERMs, which are permanent labor certifications used for eventual green card sponsorship? All right, let's get started. Number one, don't be late to the party. The PERM process is a lengthy one, and processing times are always subject to change and can range anywhere from 9 to 14 months. In the unforeseen case of an audit or a request for additional evidence, it can take an additional 6 to 7 months to process under what's called audit review. This is always subject to change and is typically tied to the economic status of the country at any given time. But in the meantime, for employers, as soon as you are happy that you are with an H-1B employee, or maybe you have a foreign employee that you're trying to sponsor, or you want to keep them on board, if they're here in the US, they're an asset to your company, you want to start the PERM process right away. There's no reason to wait until the 4th or 5th year of their H-1B if they're on H-1B. There's a 6-year limit on H-1Bs, and in order to avoid any additional stress and having to rush or worry about running out of time, it's best to start the process as soon as possible. So don't be late to the party. Number two, you have to show that you can pay to play. Ensure your sponsoring entity is a viable one is part of this process. And in the future, after the labor certification is filed, you will file an I-140, which is an immigrant visa petition, employment-based. And you will have that denied if you can't show the ability to pay. So what you'll have is a prevailing wage that's set forth by the Department of Labor, and then you submit that labor certification, and if it's approved, you have to be willing and able to pay that amount for the job once that person gets their green card. So once the PERM is certified and you move on to the I-140 process, you will need to show proof that your company's ability to pay and that the sponsored employer's salary or prevailing wages issued by the Department of Labor is coverable by your company. That's shown by your financials, which is your most recent tax return, federal, state, and quarterly wage reports and returns for the most recent 4 quarters prior to filing, or an audited financial, which become very expensive. So you want to make sure that you have that ability to pay and you can show it in those documents before you submit a labor certification. Number three, to EB2 or to EB3, that is the question. You hear a lot about filing under the EB2 or EB3 categories. The EB2 category is reserved for those professionals who have learned an advanced degree, such as a master's or PhD. History has shown that the EB2 category for professional workers with an advanced degree or extraordinary abilities has always been the preferred category, as it's typically faster when it comes to annual visa availability. That's according to what's called the visa bulletin. And sometimes this does shift, but the question is EB2 or EB3. So this is especially important when you're going to then file for adjustment of status, and is the case for workers who come from countries with limitations on annual visa numbers, including India and China. Another positive to the EB2 category is that the EB2 I-140 petitions, which come after labor certification, are eligible for premium processing. This is also something that has shifted over the years. It's important to keep this in mind. But this is very important for cases where an H-1B worker is nearing his or her last year or 6th year, and the I-140 is approved, then they can be eligible for an additional 3-year extension of their H-1B status. So to qualify for EB2, the position must require at least a master's degree or a bachelor's degree plus 5 years of post-bachelor experience. The EB3 category is for those professionals who possess at least a bachelor's degree. A combination of academic and work experience equivalent to a U.S. degree is evaluated by a professional credential evaluation service, or what's called skilled workers. So those were the EB3 professionals, and you also have skilled workers, which include positions that don't require degrees, but do require specific experience for positions, including machine workers, bookkeepers, cooks, restaurant managers, etc. The processing times for EB2 and EB3 can vary and are in accordance with the National Visa Bulletin, which of course is updated by the US Department of State each month. So if ever in doubt of whether or not to choose the professional, whether the qualification is EB2 or EB3, sometimes it's safe to apply under EB3 if you're not sure. What you don't want is for the case to be denied because you misclassified it. So if it's not clearly EB2, then you go for the EB3 category. Number 4, communication is the key, in this case to efficiency. Once the Department of Labor issues the prevailing wage determination, we enter what's called the recruitment phase of the process. The recruitment phase consists of 2 parts, the 30-day active and what's called the 30-day quiet period. During active recruitment, your attorney will place required postings for the position in various approved ways per the Department of Labor's PERM qualifications or regulations. Once active recruitment is complete, you must wait 30 days before you are able to submit the PERM application. During the recruitment phase, it is imperative that the employer assign a company representative who has the ability to give this process all the time and attention it requires, as this phase is time sensitive. Not to mention, in order for your attorney to be as efficient as possible in processing your PERM application, an open line of communication with prompt responses from your company is key to making sure this is a smooth and successful process for you. Number 5, don't go overboard on position requirements. The PERM application is a test of the US labor market. This means that employers are required to conduct a good faith recruitment effort to ensure that they cannot find a willing, able, and qualified US worker to fill the open position before they are able to hire a foreign worker. When drafting the job description for the PERM, the first thought an employer might have is to tailor it to the foreign worker's qualifications. This is absolutely not allowed and will yield a denial of the application. The open positions requirements must be normal for the occupation across the board and in line with the US Department of Labor's typical requirements for the same or similar occupation per the Bureau of Labor Statistics. An experienced attorney will be able to guide you in drafting these requirements based on your own needs for that position. Number 6, keys to victory. How do you win recruitment strategies or devise them to maximize success? Whenever possible, especially if times of high unemployment, it is always a great strategy to recruit for 2 open positions. This way, in the event a qualified US worker applies for the position, you can hire the US worker and the foreign worker. Additionally, it is always important to be as specific as possible when drafting the requirements for the open position. Think of all the necessary tools and technology a candidate would need to have theoretical and/or knowledge of in order to conduct the duties in a successful manner. You can also add experience within a specific sector or industry. So the keys to victory are having a winning strategy from the beginning. Number 7, be progressive. This refers to progressive experience with the sponsoring employer. It can be used. In the event the foreign worker has worked with the employer's company for some time and has gained progressive and essential experience for the offered position, that can be used. To do this, this employee must have gained the experience in various progressive positions or a position with at least 50% less responsibility than the position offered. This requires a lot of detail and job in the description in detail of duties for these progressive positions as compared to the one that's being offered in the PERM process. So for example, in the case of a farmhand, the position called for 1 year of experience in either the position offered or 2 years as an assistant farmhand. As the foreign position foreign worker gained the 2 years of experience working as an assistant farmhand, that case was certified and the ensuing I-140 was approved upon submission of a letter from the employer confirming the experience as an assistant farmhand. The requirement was either 2 years of experience in the position offered or 60 months of progressive experience in various positions leading up to the offered position. The foreign worker began with the sponsoring employer within an entry-level position as a machine worker. This is another example. He then worked his way up over the course of 60 months in progressively responsible positions and that experience was used toward the offered position. That case was also certified. So these are just two examples of how you can use progressive experience in order to potentially qualify under PERM. It is important to note, however, that in the event progressive experience gained with the sponsoring employer is necessary to use within a PERM, it can trigger an audit which would slow down the process by about 6 months. So that is something to consider when drafting your position requirements, meaning if there's no way around using the progressive experience, you need to be ready for an audit. And if that's your only choice, then you need to use that. Number 8, it's all in the details. Prior to beginning the PERM process, it is always important and extremely helpful for an attorney when a foreign worker has gone over his resume, his or her resume, and given as much detail as possible for each previous stint of employment. This includes specific start and end dates of previous employment in the month, date, year format, as well as actual position title. This will allow the attorney to have a better understanding of exactly how many months of prior applicable experience an employee has gained as it pertains to the open position's requirements. Additionally, include all of the details of that experience as it applies to the open position, i.e., what are some of the things you did in your previous position that apply to the position within your PERM application. Add in information on specific tools and technology you gained, including theoretical knowledge, your academic knowledge, any certifications you may have earned, and other working knowledge and skills you gained on the job during your previous employment as it would apply to the position for which you are being sponsored. So it's better to give as much detail as possible, and if you have a good attorney, they will figure out which information is useful in crafting the specifics of this labor certification application. Number 9, prove it or lose it. If you have the experience, now you have to prove it. Once the job description has been nailed down for your PERM application, it's important to start compiling the documentation needed to prove you meet the position's requirements. The main items needed are experience letters from previous employers corroborating the dates of previous employment that will be entered on your PERM application. These letters must also be within a specific format and include information such as the terms of previous employment, full-time or part-time, how many hours per week, the position title, previous employer's requirements for that position, previous employer's location, and short bio. An experienced immigration attorney will be able to assist in drafting those letters based on sample experience letters and making sure that a lot of the prerequisites for the position that's being listed on the PERM are included in those experience letters to show that those requisite skills and experience have been obtained in previous employment. Last but not least, a tribute to Michael J. Fox here, we're going back to the future. And what that means here is that recaptured time and this clause called AC 21-106A are very important. In the event you find yourself nearing the end of your 6 years in H-1B status and are just beginning the PERM process, it is a good idea to begin making notes of all your time spent outside the United States while in H-1B status. Time spent outside of the United States can be added to the 6 years you are allowed to spend inside the US in H-1B status. This is called recaptured time. A good immigration attorney will understand how to utilize this in order to ensure you are eligible for a 7th year extension based on the timely filing of a PERM application and the AC 21 rule, which enables an H-1B worker to extend his or her non-immigrant visa for a 1-year period if the PERM is submitted at least 365 days before the worker's last or 6th year in H-1B status, meaning you need to think about recapturing that time before it's too late. If you have any additional questions about the PERM process, please let us know. You can reach us at smaggi@smalawyers.com or go to our website and type in a query at smaimmigration.com. Thanks so much for watching. Have a great day.